Supreme Court has spent decades saying that it hates judge-made law. Federal courts shouldn't be creating rights out of thin air, they say, except when it comes to protecting government officials who violate your rights. Then suddenly, judge-made law is just fine. In fact, they keep expanding it. Today, I'm breaking down the Supreme Court's most brazen double standard. I'm Brandon Grable, civil rights attorney, and this is part 3 of my series with Professor Alex Reinert on qualified immunity. We've covered how the doctrine is built on errors and how states are fixing it. But today, we need to talk about something that reveals just how broken the Supreme Court's logic really is. Just quick background. You've obviously heard of Section 1983. That's the law that lets you sue state and local officials for violating your constitutional rights. But what if a federal agent violates your rights? I've already done a video on this, but here's the kicker. There's no statute for that. So in 1971, the Supreme Court created one out of federal common law, one out of thin air. They call it Bivens, named after the case.
Bivens started in 1971, and at least for the first decade, was really seen as almost a direct analog to Section 1983. But again, Section 1983 only applies to state and local officials. Bivens was going to apply to federal officials for whom there's no statutory right to sue for constitutional violations.
Bivens is judge-made, federal common law. Supreme Court just created it. For about a decade, it worked pretty similarly to Section 1983. If a federal agent violated your Fourth Amendment rights, you could sue. If they violated your Fifth Amendment rights, you could sue. Then something changed.
As the court starts to become more hostile to federal common law from 1980 on, it starts to cut back on Bivens doctrine. It starts to cut back on other implied causes of action.
The Supreme Court decided it didn't like federal common law anymore. Too much judicial power, they said. Courts shouldn't be making up rights. It should be Congress's job. So they started gutting Bivens. Today, you can barely use Bivens for anything. The court has created so many exceptions and carve-outs that Bivens claims are nearly impossible to bring. And it's not just Bivens. The court has been hostile to all federal common law rights for decades. But here's where it gets interesting.
Yet it doesn't also cut back on some of the federal common law defenses that it recognizes. Qualified immunity is one.
You understand that? The court cuts back on federal common law rights, but it doesn't cut back on common law defenses. Rights? Bad. Judge made? It needs to go. But defenses? Perfectly fine. Keep expanding them. That's the double standard. Qualified immunity isn't the only example. There's something called federal contractor defense.
But then there's like the federal contractor defense recognized in the Boyle case, in which a military contractor was sued for a common law tort, and the court created a federal common law for that contractor, common law defense.
A military contractor gets sued, someone's been harmed, and the Supreme Court creates this brand new federal common law defense to protect the contractor. Remember, this is the same court that says it hates federal common law, but apparently that only applies to rights, not defenses. And it's happening again this term.
This term, there's going to be a case, Hensley versus Fluor Corporation, which poses the question of whether or not to expand the Boyle federal common law defense to a different context. And I'm really interested in what the court does there.
Argument next in case 24-924, Hensley versus Fluor Corporation.
This case arises out of an enemy attack on U.S. military forces on a foreign battlefield in time of war. Petitioner sued Fluor under South Carolina tort law for failing to prevent that act of war. Those state law claims are preempted because they conflict with uniquely federal interests. Applying tort law on a foreign battlefield would hinder the federal government's exercise of those powers. The purpose of tort law is to discourage risk-taking, but waging war often requires contractors to take risks, putting their lives and the lives of others in danger. Petitioners' claims also weaken the military's control over combat operations. Contractors are part of the total force, and the military cannot successfully wage war without them.
Mr. Mosier, your position extends to a case in which the contractor does something that's an explicit violation of government policy. So just assume, which I know you contest, but just assume for a moment that a provision in the Fluor contract made it quite clear that Fluor was not to operate in the way that Fluor, in fact, did. What is the uniquely federal interest there?
So the uniquely federal interest, we would still define it as the federal government's exclusive authority in determining how to wage war. Where we would see the conflict, even within the situation in which there has been a finding of breach, is when state law is trying to impose additional or different sanctions than the military. So here they point to the finding and the determination where the Army has said that there was a violation of contract, but the Army determined that what was in the military's best interest was not to terminate the contract, but to continue to work with Fluor going forward. The military could have terminated the contract.
If that's the case, what you're saying is the military should decide this. What do you do with the regulations, which, as was discussed earlier, would seem to permit liability in just these circumstances?
I'm saying not in these circumstances. The regulation recognized and told contractors there could be liability in certain circumstances, and we recognize that. Under the test, as I was talking about.
It says, unless you're exercising specific control over the actions and decisions, you're not going to get Boyle. That's what the government told contractors like Fluor. Why isn't it fair to hold you to that?
So we're not asking for Boyle, the preemption under the rule in Boyle, which applied the discretionary function exception. And what was different about Boyle, although it did involve a military contractor, obviously away from the battlefield in a time of war, it adopted a rule not based on the war powers because that rule applied to all government contractors. But what the government has been consistent in saying for over a decade.
So you're asking for something different than Boyle because that was a contract case, and DOD told folks under Boyle you're going to lose in circumstances like this, or you might lose in circumstances like this. So you're asking us to invent a new supplement to Boyle.
It's a different rule that is based on the different uniquely federal interests. The uniquely federal interest that the court fashioned a test on in Boyle was a uniquely federal.
One might think that it would help the military to immunize all contractors, and there's some good arguments for that. But there's another good argument on the other side, which is, well, maybe the military benefit most from having efficient contractors who are less likely to cause harm to military members. Why isn't that a judgment really cries out for congressional decision? And what expertise do we have in setting that rule?
So on that point, I would say this court doesn't have expertise, and has said that in a number of cases, determining what would best serve the military's interests on the battlefield. But this gets back, I think, to Justice Kavanaugh.
So why not just apply Boyle and be done with it?
Because what we have at issue here is the uniquely federal interest of the federal government's exclusive power to wage war. That was not what the court addressed in Boyle. And I think what is notable.
To answer that question, we have to decide how important is it for the military to have contractors not fearful of liability versus how important is it for the military to have contractors who don't injure military members, right? That is what you're asking us to weigh, and you're asking us to come down on one side rather than the other, and I don't know.
It seems to me you're saying state law can't operate because this is a federal enclave that has to be governed exclusively by federal law because of the federal interest in the war-making power that states don't have. But then you still have to decide what rule operates, and you're saying, and the rule that should operate is one of immunity for contractors.
What the rule that would operate is that the court would leave this area of common law to Congress's control. Congress has legislated in this area. Congress can adopt rules and create causes of action. But in the absence of congressional action, yes, we would say a state law claim or a tort claim.
Why
aren't you?
Proceed. I'm sorry, could you finish that? In the absence of congressional action, what?
A tort law claim would not be allowed to proceed.
Counsel, that's sort of turning things on its head. Preemption on its head. It's like Congress has to act to overturn our presumption. But why did we have Boyle at all?
If the court is being true to its hostility to federal common law, it should run maybe against common law defenses even more than it might run against federal common law claims. But that's not the way it's happened here.
The court has a case right now about whether to expand a federal common law defense. Think about it. They're considering expanding judge-made defenses while simultaneously refusing to recognize judge-made rights. If they were consistent with their principles, they'd be running away from the defenses. But they're not. Here's the pattern. Remedies, narrow them. Bivens claims, almost impossible to bring. Section 1983, weakened by qualified immunity. Defenses, expand them. Qualified immunity gets stronger every decade. Federal contractor defense, let's make it bigger.
So that's another reason why I think that if the court was adhering to its principles consistently, qualified immunity would be more tenuous.
It wouldn't survive scrutiny. Because if the court really believed what it said about federal common law, qualified immunity would be the first thing to go. It's judge-made. It's not in any statute. It contradicts congressional intent. Everything the court claims to oppose. But somehow, it survives. Why? So I asked Professor Reinert, is this sustainable? Can the court keep doing this?
Well, I mean, to the extent it all lies in the hands of 5 justices, it's sustainable. I mean, they can, they can keep that world going. It's a world in which litigation, especially civil rights litigation, gets more and more difficult. So I think in that sense it's sustainable. I don't think it's sustainable from a perspective of consistency and first principles. But that's a different question.
Justices. That's what it comes down to. If 5 justices want to keep this double standard, they can. They control the precedent. They decide which cases to take. They write the opinions. They control the majority. But from a perspective of principle, of consistency, it doesn't hold up. The logic contradicts itself. You can't say you hate federal common law, but then protect and expand federal common law defenses. You can't narrow remedies for constitutional violations while broadening protections for the people who violate those rights. Unless, of course, the principle isn't about federal common law at all. Maybe the principle is about something else. Making it harder to sue the government? Making it easier for officials to escape accountability? If that's the principle, then everything else makes sense. This isn't just about Bivens or qualified immunity. This is about access to justice. When the Supreme Court narrows Bivens, fewer people can sue federal officials. The courthouse doors are simply shut in their face. But when they expand qualified immunity, fewer people can sue state officials. Again, courthouse doors are slammed shut in their face. When they create and expand things like federal contractor defenses, fewer people can sue government contractors. You see the pattern? Every move makes it harder to hold power accountable. And they're doing it with the very tool they claim to hate, federal common law. What changes this? How does this double standard end? Honestly, it probably requires the court to take up qualified immunity directly, to confront the inconsistency, to explain why federal common law is bad for rights, but good for defenses. And right now, they're not doing that. They keep denying cert. They don't want to review them. They simply just keep avoiding the issue. But lower court judges see it. And if you're a litigator or you have a civil rights lawsuit, you need to be bringing this issue up if you can, if it makes sense strategically. Because we need to keep the lower courts writing opinions pointing it out. Judge Willett, Judge Calabrese, judges across the political spectrum are saying it just doesn't add up. And we need more and more opinions like that. Why? Well, obviously, those opinions keep building a record.
I think lower court judges probably, their position has to be, I can't do away with qualified immunity, but I can call attention to the issue and hope that the court will take it up and tell us what to do about some of this research.
That's where we are. A Supreme Court that says one thing about federal common law and does another. A a doctrine of qualified immunity that survives only because 5 judges allow it to. A growing chorus of judges, scholars, and practitioners pointing out that none of it makes sense. The Supreme Court's position on federal common law isn't a principle, it's a tool. They use it when it helps narrow rights, but they abandon it when it's about protecting rights. That's not jurisprudence, that's just power. So the next time someone tells you the Supreme Court is just following the law, just applying neutral principles, remember this. Remember how they treat Bivens versus how they treat qualified immunity. Remember the federal contractor defense. Double standard isn't a bug, it's a feature. Next video, we're covering the forgotten legal distinction that could change qualified immunity cases nationwide. A rule from the original 1982 Supreme Court case that just disappeared. If lawyers start using it again, maybe things could change. A link to Professor Reinert's research is in the description. Subscribe for the final video in the series. This is Clearly Established. Thank you for watching.